Hello, and thank you for visiting my YouTube page. My name is Jamaal Jones, and I'm an attorney with Jones Health Law. We're based in Miami, Florida. Today, this video is going to discuss business and legal considerations for selling a physician practice. Physicians may determine that it is in their best interest to sell their medical practice for various personal and business reasons. A few of the reasons why a physician may choose to sell their practice is because they're retiring, they're relocating to another city or state, maintaining the practice is too much of a burden, it's too stressful, they're physically unable to meet the demands of the practice, lower reimbursement rates causes them to do a cost-benefit analysis, and they determine that it's not in their best financial interest to continue with the practice, or someone simply made them an offer that they couldn't refuse. But regardless of the reason why a physician may choose to sell his or her practice, there are certain business and legal considerations that they should factor into the decision process. Well, who's buying physician practices? Florida is one of the few states that allows for a non-physician to own a medical practice, excluding optometry, dentistry, or chiropractic practices. Large corporations, private equity firms, hospitals, health systems, and ambitious physicians looking to expand their practice are all common buyers in today's market. Due to healthcare reform, the value of physician practices are diminishing in many markets. Which leads me to my next point. What is the value of my physician practice? Is something that my clients ask me all the time. Now you want to consult with someone who can do a fair market value analysis, and I'll get into that in a few. But many business owners, including physicians, have an idea in their head of what they think their business is worth. Often there's an emotional component that is factored into what the physician perceives their practice to be worth. I encourage my physician clients to be realistic with their expectations. Let's face it, there's no guarantee that patients will remain with the practice once their beloved physician departs, and purchasers are aware that while there is some benefit to buying an existing practice, there is also significant risk. For this reason, many purchasers choose to pay the purchase price over several months after closing and hire the prior owner as an independent contractor during the transition. I advise my clients to meet with a healthcare consultant and bankers who are primarily in the medical and dental industry so that they can determine what the fair market value of their practice is. A fair market value is partly based on the tangible assets of a practice and consists of all furniture, fixtures, and equipment owned by the practice, such as examination tables, desks, chairs, and medical equipment. There are numerous methods and factors to be considered in determining the value of a physician's practice when preparing to sell. The value of a physician practice fluctuates based on A, the payer mix, B, referral sources, and C, the presence of ancillary services. If a practice has one or more ancillary services that it provides, that can dramatically increase the value and eventual purchase price of your practice due to increased profit margins. The process includes requirements or rules that must also be followed in order to legally sell a practice. All legal and business considerations should be addressed to ensure that the selling physician receives the best possible price for the sale of their practice. The selling physician must be careful to avoid any actions that can reduce the value of the practice during the sale. Sellers must be careful not to misrepresent the terms and conditions of the physician practice because it's highly likely everything will be discovered during the purchaser's exclusive due diligence period. The selling process ends with a negotiated agreement with attorneys covering the asset purchase agreement, revised partnership agreement, if applicable, and employment agreements to name a few. During the closing process, all agreements will be signed and executed. Now, I know what you're thinking. How do I structure the sale of my physician practice? The sale of physician practices can be structured in various ways, depending on the facts and circumstances specific to that particular practice, such as debts, obligations, and leases. Those are all things that need to be taken into account when structuring the sale. A physician has to choose between selling stock in their practice, assets, or in some cases, a combination of both. A physician that sells stock in their practice will pay less taxes on the purchase price. However, purchasers are wary of purchasing stock because they assume responsibility of their practice's liabilities. The trade-off with a stock purchase is that the purchaser retains the physician's payer contract's tax ID number, resulting in a much smoother and faster transaction. In an asset purchase agreement, the physician has to be very specific about what is included in the sale. Maybe certain art or furniture aren't included, for example. In this strategy, the physician seller positions the sale as an alternative to a startup practice. The value is not as high, but a small amount of intangible value can be justified for things such as the speed when compared to that of a startup, less losses than a startup. You have a trained workforce already in place, telephone number, website, historical marketing already in place, medical equipment and furniture are present on the premises in the facility, and there's also a stronger patient base and reputation. A transaction involving the value of intangible assets of a practice could trigger violations of various state and federal healthcare laws, including but not limited to the Florida and federal anti-kickback statutes and START law. Tangible and intangible assets can all be included in the sale of a physician practice. However, to avoid anti-kickback issues, the final price must not overwhelmingly exceed the fair market value of the practice. If the purchase price exceeds the fair market value of the physician practice, it will be a red flag for regulators. Regulators might interpret the sale to be disguised as an impermissible payment for patients or patient referrals, also known as patient brokering in Florida. You should always consult with a healthcare attorney to conduct an analysis of START and anti-kickback statutes before proceeding with the sale. The sale of a physician practice may include a competitive auction process. Smaller physician practices don't usually go through this auction process, but it's not uncommon for a larger practice with several offices and expensive medical equipment to go up for auction with a minimum reserve that must be met. All parties involved must agree to the terms and the price. A competitive auction includes an invitation of greater than 20 buyers to bid. Buyers in competitive auctions typically have a 6-week deadline to submit a letter of intent to purchase at a tentative price pending exclusive due diligence performed by the buyer for 60 to 120 days. Now, how do you protect your practice? Physicians spend a significant amount of time, devote countless hours to building their practice. It's not always easy to part ways with your practice, but prior to completing the sale, you want to make sure that you and your practice are adequately protected. No matter the size of your practice, when you're entertaining offers from potential purchasers, a well-crafted non-disclosure agreement should be drafted by a healthcare attorney and signed by those potential purchasers. The non-disclosure agreement, or the NDA, ensures that any documents or information that they receive during the negotiation process will be returned, destroyed, or kept confidential, or else there will be a lawsuit for resulting damages. Also, the information gathered during the negotiation practice, such as trade secrets, can't then be used to directly compete with you. Once signed, the potential purchasers are given access to secure online data rooms, which include financial statements, confidential information, memorandums or pitch books, and operational statistics. Now, what if you own the practice and the real property that your practice is on? Physicians that also own the practice facility need to prepare for the sale of both their practice and the practice facility. Alternatively, if a physician is interested in keeping the practice facility, he or she can lease the space to the buyer of the practice. In the leasing agreement, the physician may give the buyer an option to purchase the facility in an amount of time specified. If the selling physician wishes to remain employed by the purchasing party, remaining a landlord represents a conflict of interest that needs to be addressed. Therefore, the selling physician should contract for the sale of the practice facility with the buy-in party or an independent property management business. Now, just to kind of sum up a few points, I'd like to lay out a brief list of legal considerations for the sale of a physician practice. First, you want to beware of fee splitting and kickbacks. Structure the transaction in a legally permissible way such that it doesn't violate any applicable healthcare or business laws. Purchasers must conduct due diligence. Physicians must protect patient protected health information, or PHI, account for and protect against any data or information breaches or potential data or information breaches. Resolve any existing contract disputes. Determine whether you can assign third-party contracts. Negotiate the non-competition clause. Negotiate an agreeable indemnification clause. Adhere to any termination provisions. Consult with a CPA to determine the tax risks. Transition the non-physician employees appropriately. In addition to these considerations, there are many other factors to consider before deciding to purchase or sell your practice. The sale of a practice can be completed overnight and can take several months. The purchaser may have to obtain a healthcare clinic license and ensure that the transaction does not violate STARK or meets one of its exceptions. It's up to you to determine whether the time is right to sell your practice. No matter the size of your practice, you should always consult with an experienced healthcare attorney. Again, I'd like to thank you for taking the time to look at my video on the business and legal considerations for selling your physician practice. If you have any questions, please feel free to leave a comment on this video, or you can contact me directly by calling 305-877-5054 or emailing me at jrj@joneshealthlaw.com. You can visit our website at www.joneshealthlaw.com for more information about some of the services that we provide. Thank you very much.